Let me go to Representative Schultz.
Thank you, Mr. Speaker. Motion to uncircle first substitute HB 241.
Motion is to uncircle first substitute House Bill 241 post-employment restriction amendments. Seeing no lights, I'll place the motion. All those in favor say aye.
Aye.
Those opposed say no. Will that motion passes? The bill is uncircled and before us. Representative Schultz.
Thank you, Mr. Speaker. HB 241 post-employment restriction amendments deals with non-compete agreements that an employee, or rather an employer, would make an employee sign during their time of employment at a particular company. And HB 241 is specific and first substitute and only is addressing the broadcasting industry. Representatives, this is not unique to Utah. There are 9 other states, including D.C., that have non-compete severe restrictions on how non-compete agreements can be used, in some cases banning them altogether inside of the broadcasting industry. And so this is an issue that has came up in those other states, and they have dealt with that as well. So in conjunction to that, there are 3 states altogether that ban non-competes in the state with all industries. So this HB 241 only is particular to the broadcasting industry, and I'll speak to that at the proper time. So, but let me, representatives, go over what first substitute HB 241 does and does not do. HB 241 does not allow a broadcast employee under the Fair Labor Standards Act to enter into a non-compete agreement. Now, that Fair Labor Standards Act, as far as the salary, is currently at about approximately $47,500 per year. So an employee under that threshold would not be able, or would not be subject to a non-compete agreement. Now, those employees that are above that wage number, that's in the Fair Labor Standards Act, which is again currently $47,500, would be or could be subject to a non-compete agreement under certain circumstances. And that's what we're going to address with HB 241. Those circumstances are, I've heard a lot of people talk about protecting the right to contract, and so this would allow those employees to enter into a contract that are over $47,500 per year in the Federal Labor Standards Act, to enter into a contract that an employment contract that has a non-compete agreement attached to that. Now, it would come with some restrictions, representatives, and let me go over what those restrictions are. The employment contract would not be able to go longer than 4 years, and if that employee is fired with just cause under the terms of that contract, or if they're fired with just cause, that non-compete agreement could be enforced. If the employee breaks that contract, that non-compete could be enforced. If the employer breaks or cancels the contract under that non-compete, if it's the employer's decision and the employer does it, then that non-compete could not be enforced. And then at the end of that contract, the term of that contract, an employee cannot be held to a non-compete agreement. At that point in time, the employer and the employee would have to sit down and renegotiate their contract. Now, that could be done prior to the end of that contract, and so but if that contract comes to the end and no agreement has been reached, at that point in time there would not be a non-compete that could be attached beyond the term of that contract. So, and then in no other circumstances could a non-compete exceed 1 year. Representatives, The support from the journalists and from the on-air broadcasters, those working behind the scenes, the producers, have been absolutely overwhelming. I've sent out a packet, most of which those stories that you read in those packet, the names have been redacted because they've asked to be anonymous. They would not like their names mentioned because of the fear that comes with coming out publicly and being under a non-compete agreement. The opportunity that they may get fired or retribution may come from their current employers. And so most of them have asked that they remain anonymous. But as you can see through those letters, there is strong support with that inside the broadcasting industry. A lot of people have asked why we're going to just the broadcasting industry. And representatives, as you are well aware, I've been at this issue for several years now. And as I look around and hear the different stories, and as these issues are brought to me, it is clear to me that the abuses inside the broadcasting industry with these non-competes are widespread. Other industries, as we look at the industry as a whole, while certainly there's some bad actors and employers inside those industries that abuse non-competes, from what I've seen, that are not widespread inside the industry. Until you come to the broadcasting industry. And the stories that I've heard of people signing non-compete agreements, thinking they're, get hired as a on-air talent, and then, being on air for a while, and then being asked to move to another job inside that maybe they're a producer writing stories or something like that, and that person did not want to move. They wanted to continue to be an on-air talent. However, their employer made the decision to move them over and to a different job and change what their scope of work would be altogether. In a lot of cases, the employees were not happy with that. However, they couldn't do anything. They had to continue to work for that employer and stay under that agreement, because if they quit, they wouldn't be able to go outside of that, into another station or another company and work because of the non-compete agreement. Representatives, a couple years ago, you'll remember that we passed laws restricting them to 1 year on the non-compete agreements. I want to stand here and tell you that I've seen contracts inside this industry that go beyond the 1 year. They say that it's from the time of termination. Well, if you're in a 3-year contract and you terminate it in the first year, according to that contract, you could have another 3 years with a non-compete agreement. And so while that's not the case for all of the contracts that I've looked at, that is the case for some. So representatives, I hope that you'll support me in this endeavor and help curb some of the abuses that are happening out there inside the broadcasting industry. And with that, Mr. Speaker, I'm open to any questions that the body may have.
Thank you. Discussion to the bill. Representative King.
Thank you, Mr. Speaker. I wanted to call the attention of the body to one salient fact from my perspective about our laws here in the state of Utah. We live in a right-to-work state. What that means, these are statutes in place in 27 states, we're one of them, that prohibit union contracts between companies and workers' unions from compelling employees to join a union or to pay any part of the cost of union representation, while at the same time generally allowing those employees to receive the benefits of union representation. It encourages free riders, in my humble opinion. I'm not a fan of right-to-work laws. But let me tell you one thing, Mr. Speaker. If you want to live in a right-to-work state, if you want to be a legislative body that promotes right-to-work laws, you better allow employees to leave and compete and take their labor elsewhere freely. I think that's only fair. I think that it's critical that we be even-handed in dealing with employees here in the state of Utah who are burdened by, from my perspective, burdened by right-to-work laws, that we be even-handed in saying we're going to allow individuals to freeload at times in getting the benefit of union representation without paying the cost. But we're also going to be even-handed and fair in allowing employees, when they terminate their employment and leave, to have either no restrictions on their ability to go out and market their labor to other employers, or under certain circumstances, as this bill reasonably does, limit the ability of a prior employer to keep these employees from going out and making a living and providing for themselves and providing for their families. I support this bill. I think it's important that we make a statement as representatives of the people of the state of Utah that we support employees and working families and working individuals in the way that this bill does. I appreciate the bill sponsor's efforts to carefully craft this, taking into account reasonable concerns and objections from individuals who would have us allow for even stronger and stricter anti-compete provisions in contracts, and I think this is a good movement in the right direction. I'd encourage your support of it. Thank you.
Thank you. Further discussion to the bill. Representative Hawks.
Thank you, Mr. Speaker. I rise in strong support of this bill. First off, just wanted to commend the sponsor for the extraordinary amount of work that he's invested in this issue over several years, and the extraordinary effort he's invested just this session to dial this down and land in the right spot. I want to speak to the legal aspects of this. There's a concern that's been raised. Many of you have probably heard it. Question comes up, they say, well, why pick on the media? You shouldn't pick on the media. If you're going to impose this, you ought to impose it on everybody. Well, I'd submit that the answer, the reason that we have to single out the media in this case, goes to the heart, really, of the First Amendment. It goes to the heart of freedom of press. The First Amendment is built on an idea of marketplace of ideas, that all voices are able to be heard, and that in that contest of ideas, that truth will prevail. Well, the problem in this case is that non-competes are silencing media voices. They are by nature anti-competitive. And if you think it's just a case or two, please read the packet and the countless stories of people in the media that have been directly affected by this. The reason this bill singles the media out is because the media is uniquely positioned to be a voice of trust in our homes and communities. And so, where we might be concerned about non-competes from an economic standpoint in a corporation, just kind of in an abstract way, that doesn't implicate freedom of press, that doesn't implicate the First Amendment. But where media voices are silenced, that implicates the quality of the news that we get, the quality of the information that comes into our homes. And so again, that goes right to the heart of the First Amendment. I would ask my colleagues to look around the room right now and tell me, do you see any cameras? We have big bills up here all the time. We have issues affecting, here we have a big bill. We have affects the media. There's no cameras here. So tell me, colleagues, how that is not a First Amendment problem. That we have an issue that the media will not report on it. How many television news reports have you seen on this issue since it hit the light of day? We've had newspapers report on it. We haven't seen anything in TV. That, I submit, colleagues, is why we need to be concerned about that. That is why the media is being singled out. Because they have to be. In the name of protecting free press, in the name of protecting the First Amendment, that's what we're doing. I'm confident that this is on firm legal ground, that it will withstand any challenge, and that we need to act to protect the role of the media and free press in our democracy. And with that, I'd urge your support. Thank you.
Thank you. Further discussion to the bill. Representative Nelson.
Thank you, Mr. Speaker. I've struggled with this bill. I appreciate the substitute bill. I think it is an improvement. and I was hoping that we would have more time to allow the industry to review the substitute. But under the circumstances, we're talking about it now, we'll consider it now. I realize we've had some impassioned speeches in support of the bill. I can't match the passion, but I can match the legal reasoning and the policy. And I think that I must come down against this bill for several legal and policy reasons. The first reason is that it does single out a single industry, a particular industry, and in fact only a handful of employers. Both of our constitutions that we are sworn to uphold, our state and federal constitutions, prohibit laws, private or special laws. Our state constitution, Article 6, Section 26, prohibits private or special laws where a general law can be applicable. Special legislation is defined as legislation that targets a particular industry or entity. Like I say here, it's targeting a handful of employers in the media industry. If non-competes are so evil, if they are so destructive, if they are so violative of employee rights, then let's apply the prohibition across all industries, across all employers, not just pick out one industry with 5 employers. We sometimes do pass laws that favor particular industries, such as a tax exemption or something like that, to encourage commerce. But in this case, we are passing a law, we are proposing a law that will burden particular employers. That is the definition of a special law, where this law could be applied generally. We're applying it specifically to a single industry and a few employers within that industry. Therefore, it does violate Article 6, Section 26, the prohibition against special laws. We also have provisions in our state and federal constitutions against the impairment of contracts. One of our basic premises in our form of government is the freedom of contract. That's why both our federal and state constitutions prohibit impairment of contracts. It's in deference to the freedom to contract. Whether it's an employer or an employee, they're free to enter contracts. And so here, if this law is passed, the effect of it will be to impair existing non-compete contracts. What we're saying is, as a legislature, we disagree with the contract that you've privately negotiated, that you've privately agreed upon, and we're going to void that contract that you've both agreed to. The Constitution prohibits that for obvious reasons. Number one, it violates that basic liberty, that basic freedom of contract. And so constitutions protect that basic freedom. The other legal protections, of course, is our uniform protection of laws. Because we have singled out a particular industry and a few employers, we've left untouched numerous industries, numerous employers, healthcare, high-tech, trucking, whatever it is, and we've said everybody else can use these non-competes, but only one industry cannot. And so under an equal protection analysis, we would have to justify that distinction. We would have to justify in a court of law, why are you targeting an industry? Is there an important government reason to do that? And in fact, the challenge would be based on the First Amendment, freedom of speech, freedom of press, which would heighten the scrutiny that the court would apply, that would require that the law satisfy a compelling governmental interest and is narrowly tailored to meet that compelling governmental interest. I don't think we can meet that standard here. Again, if we're concerned that non-competes are evil, then outlaw them for everyone instead of targeting an industry. That violates equal protection. We're saying to one industry, we're going to treat you differently from everyone else. Now, some statements have been made that, well, that's justified because these are the entities that disseminate facts and truth and so forth. But don't employees of all industries have that same right to free speech? At the bottom of this, the employers that we're targeting in this bill claim that and I think rightly, that some of their employees represent them. They are the face of these employers. I remember growing up, and many of you will, I hope, that you'll remember Channel 5 had a news team called Norse, Welty, and James. I stayed up as a young man to listen to Norse, Welty, and James. I loved them. They were the face of Channel 5. And so if I had watched the news the next week and saw that Channel 5 did not have Norse, Welty, and James, but rather that Norse, Welty, and James were now working for Channel 4, I would think, okay, I like Norse, Welty, and James so much that I'm going to watch Channel 4 now. I don't care about Channel 5. And that's really the risk. That's really what these employers are talking about. They're saying that some of their key employees represent, as a name and a face, they represent the entity itself. They represent the goodwill. They represent the product, which is credibility, trust, good reputation. And so if these employees, after years of identifying themselves with a particular broadcast, they are free to walk away at any time, that destroys the goodwill, the reputation, the trust that these employers have built up over time. And by shackling them with this bill and saying you cannot protect yourself by holding these key employees to you, we are burdening their business. We are violating their rights. The rights to freedom of press, the rights to be freedom of contract, the right to equal protection, and the right against special legislation that targets only them. And so I would urge, as a matter of law and policy, this is really extraordinary, that we would propose a law that would so severely and specifically target an industry and try to burden them in their rights and what they're trying to do in their industry. This is rather startling to me. I don't question anyone's motives. I realize you have a pile of complaints from employees, but the information we have on the other side is that we have a whole list of employers that need non-competes. And when the prior form of this bill was proposed a couple of years ago, a compromise was reached that allowed for one-year non-compete contracts, and a study was done, and the survey found that 90% of employers and 74% of employees believe non-compete should be allowed, as they have been for hundreds of years. The law recognizes and upholds non-compete clauses as long as they are fairly negotiated and fairly enforced. And so I urge the body, as a basis on the grounds of law and policy, to reject this bill. If we have a problem, I think there's a better way to do it. I don't think we have a problem. I urge that we vote against this bill. Thanks.
Thank you. Further discussion to the bill. Representative Christensen.
Yes, Representatives, I understand that there's merits on both sides, which I sincerely respect, and I can see it. Here's just one other little piece of the puzzle. It's always been the law fundamentally in terms of non-compete agreements, and I've seen abuses. I've seen people in non-media professions where, when they were terminated, what they would do is, it's a hire and fire at Will State, and then they'd be living month to month. They didn't have the ability. I mean, all of a sudden, the employer would terminate them and then say, oh, but if you'll sign this non-compete agreement, we'll give you another 30 days compensation. And so they almost had to give up their ability to work in the same profession that they'd always been in because they needed that additional payment. That's the one that would argue on the side of just a blanket say no to non-competes. On the other hand, for decades and decades and decades, the courts have said that non-competes are okay as long as they are a reasonable time period and a reasonable geographic distance. So now if you try to apply it to a media, How do you have Walter Cronkite on Channel 2 on Monday night, and then all of a sudden on Tuesday night he's on another station? If you're a newspaper and you're losing in circulation to a competitor, do you just hire someone and bring them over and say, tell me what's going on over there? So they worry about unfair competition, they worry about proprietary information. That's how the courts have balanced all of this. It isn't as simple as just a blanket yes or no in any and all circumstances. So they've always said that non-compete can be permitted if it's necessary to avoid unfair competition or to protect proprietary information, and therefore it just needs to be a reasonable time period and a reasonable geographic distance. I can see at the national media level how difficult that would be, but I just hope that that sheds a little bit of light, and then, like I say, I understand people asking the question, what is it that prompted this to be singled out? I thought that the state had kind of reached the agreement, had reached the solution where they were maybe going with a one-year situation, whatever, but I just add that additional element to the dialogue. Again, reasonable time period, reasonable distance, but then unfair competition, proprietary information. How does all that apply to the media, and what unique circumstances might they have? Thank you.
Thank you. Further discussion. Representative Frower.
Thank you, Mr. Speaker. I rise in support of this legislation for a couple of reasons, and I agree with the good representative from Grantsville on the freedom of contracts. And I agree that if we were dealing with Norris Weldy and James, which I remember very vividly, that I would probably be on the opposite side of this, but we're not. We are dealing with people that are in producers' jobs at lower levels that are not the face of the station, that basically do what I would call the manual lifting, the lifting to make sure that those people that get their face in the news every night can do their job. And I think that the freedom of contract goes away with the higher faces, these people that the stations do put their brand on. But I don't think it's fair to hamstring these people that are at lower levels, that forbid them, or prevent them, I should say, from moving up the ladder, from jumping stations because of opportunities for higher pay or different jobs. And for that reason, I will be voting in support of this bill and would urge you to support. Thank you.
Thank you. Further discussion. Representative McKell.
Thank you, Mr. Speaker. I want to rise in strong support of this bill. I was in that committee, and I know we can't talk about the lengthy discussion, but I appreciate the bill sponsor. I think the bill sponsor has done a good job in the substitute, narrowing and focusing in on some of those concerns. I appreciate the comments from the good representative from Davis County, highlighting the compelling state interest. As I've sat through the debate and listened, the concern was brought forward that we are singling out a single industry. And you all saw those emails, and there's a great irony to those emails. Most of those emails, if you'll look, were sent by attorneys in big law firms. And in my industry, as an attorney, I think it's ironic that we have an absolute prohibition against non-compete agreements. It is unethical, under our rules, to have a non-compete agreement as an attorney. And I find it ironic that those same emails from attorneys, from big law firms, claiming that we should oppose this bill, they themselves, those individuals who drafted those emails, cannot be subject to a non-compete agreement. I appreciate the bill sponsor. I appreciate all of the discussion, and I would urge your strong support. I believe we do have a strong, compelling state interest in protecting free speech, and I think this bill does that. Thank you, Representative.
Thank you. Further discussion. Representative Fossen.
Thank you, Mr. Speaker. I call the previous question.
Previous question has been called. Has the effect of ending debate. Non-debatable motion. All those in favor say aye. Aye. Those opposed say no. Well, that motion passes by 2/3. We'll go back to the sponsor of the bill for summation.
Thank you, Mr. Speaker. I appreciate the comments in the debate so far. I appreciate everybody's concerns on both sides of the issue. I do want to just point out a couple things. Again, we're not banning non-compete agreements inside the broadcasting industry, representatives. We are simply putting restrictions around it. We are still allowing for the right to contract to allow these agreements, at least for the employees above the $47,500 range that is tied to the Fair Labor Standards Act. And again, we are not unique in this, representatives. There are 9 other states to specifically single out the broadcasting industry. And I believe they have done so in the things that I have read for a few reasons. And one of those, has been mentioned, is the freedom of press. Our good representative from Centerville mentioned that you haven't seen any reporting on this issue. You have reporters who have asked to report on this issue, and they've been told no, that they cannot report on this issue. You have members of the management inside those media companies, when they have a couple of their colleagues come out in opposition to HB241, you have others that have asked to come out and support and ask their management if that would be okay. And they've been told by members of their management that it would be severely frowned upon and very disappointed. They'd be very disappointed if they do so. Representatives, Mr. Speaker, that's why you're seeing a lot of these anonymous emails, is because they're nervous, they're scared for what repercussions may or may not come from that. And I think you look at listen to some of the meetings that I have been involved in. I know others of you have been involved in as well. I'd encourage you to go listen to the testimony that was given during the committee hearing. And you hear in a lot of these conversations that I've had, and I know that many of you other had, you hear those employers talking about employees as their assets, as their talents. They are the ones that found this person and made them who they are. Without them, they would be still stuck in some little podunk town and never be able to get out and be successful. And I have a hard time with that, and I think that is one of the biggest reasons why we're coming forward with this bill, as well as because of that's the way they've been treated inside that, as well as the opportunity to freedom of the press that's been made by a couple of our colleagues here today. And I also want to point out attorneys. Representative, we talked a lot about and heard a lot about singling out an industry. There's one industry that is already singled out, representatives, that you cannot sign a non-compete in that industry, and that is if you're an attorney. If you work for a firm, and a big prestigious firm, and you want to take your clients, your talents, and you want to move to another firm, you're allowed to do that. However, time and time again, we hear from these same attorneys that they would like to prohibit others from having that same ability to do so, Mr. Speaker. And I just fundamentally have a hard time with that, and I struggle with that that's the case. We boil down to the proprietary and confidential information. There's already laws in place, representatives, that protect proprietary confidential information. I also believe that, a journalist, you talking with them, doesn't really have any proprietary or confidential information. And that the reason they're being asked to sign non-compete agreements is so that those companies can lock up that talent, their God-given rights, their God-given talents to that they have made themselves successful, certainly just as any employer would have, has given the opportunity to an employee to be successful. That goes across the board. The employer always provides an opportunity, but yet then it comes down to that person's ability and their God-given talents. And I think the media is very specific to that. Again, I just want to point out one quick thing. If you're worried or questioning whether or not the media can accurately report on these or give fair analysis on this, I just want to point to the two articles, or the articles that you've seen come out from two of our major print newspapers in the recent couple weeks. Look at the one whose parent company owns them and uses non-compete agreements extensively, and then compare that to the other one who does not have non-compete agreements. And so I think that goes back to our good representative from Centerville's point that the media has been unfair in a lot of the way they have portrayed these, and the freedom of press is a First Amendment argument, and that's the argument that I'd like to stand on. And with that, Mr. Speaker, I urge the support of the body for HB 241. Thank you.
Thank you. Voting will now be open on first substitute House Bill 241, Post-Employment Restrictions Amendment. Seeing all present having voted, voting will now be closed. First substitute House Bill 241, having received 62 yes votes, 12 no votes, passes this body and will be transmitted to the Senate for its consideration.